An admission to drinking, Judge?
Okay, we don't know when. The officer can't do any more questions than that. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. Mr. McGaskey, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Please don't say it.
October 26th, officer was dispatched to a major crash in Harris County, Texas. Upon arrival, the officer observed the defendant sitting in the driver's seat of his motor vehicle with his keys in his lap and with an odor of an alcoholic beverage. The defendant stated he drank prior to driving. Standard field sobriety tests were performed. HGN 4 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The DIC was read and the defendant consented to breath, but the defendant was unable to do the test. A blood warrant was then signed and executed.
It was really quick. So where was he?
So it was a major crash in Harris County, Texas, specifically on 2201 Southwest Freeway.
Okay, and then what?
The officer arrived and he was in his driver's seat, and the officer observed his keys in his lap, and then he observed an odor of alcoholic beverage.
Just an odor. Anything else?
And then the defendant made a statement that he drank prior to driving.
Yeah.
And that's it.
Leads you to believe that he's drunk. We have an accident, I get it, but there's just an odor of alcohol. There's nothing, no slurred speech, no bloodshot eyes, just an odor.
Yes, sir. All that was written was the odor was observed, and then the statement made about him drinking.
McGaskey, I have an accident. All I have is an odor of alcohol. What can you, other than the accident, what can you lead me to believe that he's drunk or intoxicated?
The defendant stated he drank prior to driving.
We don't know how many, we don't know how much, we don't know when it was happened.
Well, Judge, I don't think that's necessary to provide probable cause for the case. He's admitting to drinking, he's got odor of alcohol in the breath, and the accident itself is evidence of intoxication, Judge. All of that, in our opinion, is enough for probable cause.
I don't think so. I mean, usually there's a lot more than just that. An odor, we don't have anything else. I don't know when, I don't know how many, I don't know how strong it is, just an odor.
Not every case has extrapolation or admissions of how many, Judge.
I understand. I understand, Michael, but I need just a little bit more than just an odor and an accident.
An admission to drinking, Judge?
Okay, we don't know when. The officer can't do any more questions than that. Okay, when did you do it? How many did you have? Did you have anything to eat?
Understood.
Yeah, all right, I'm going to find no probable cause, Mr. McGaskey. It's very possible that they take it to a grand jury and indict it, but so I would be on the lookout, number one. Number two, you know how many accidents and death we have every day due to alcohol and getting into a car? I'm going to find no probable cause. Just take a seat.
Thank you, Judge.
Thank you, Mr. Jeff.